Here in regards to that matter, sir.
Excuse me?
I'm here in regards to that matter.
Okay, you said I'm here. Who is I? Who are you?
Living man.
Well, if you're talking to me, I suppose you're living. I hope you're living, unless I'm assuming. There's nothing funny. Who are you?
My name's Roman, sir.
Roman?
Yes, sir.
Oh, are you an attorney?
Yes, sir.
Well, unless you're an attorney, you don't need to represent Mr. Daniel McDonald. You can have a seat. You said Roman,
Yes, sir.
and you're not an attorney?
Yes, sir.
What's your relationship to Mr. McDonald?
Depending.
Are you representing Mr. McDonald?
Yes.
But you're not a member of the Florida Bar?
Yes, sir.
Are you a member of any state bar?
Yes, sir.
Did you go to law school?
Yes, sir.
So how are you representing Mr. McDonald?
I would just like to ask some questions in regard to that matter, sir.
You can answer my questions regarding that matter. What's your last name?
McDonald.
So your name is Roman McDonald?
Yes, sir.
And are you related to Daniel McDonald?
I just go by Roman, sir.
You just told me that. Are you related to Daniel McDonald?
Yes, that the name on your docket is in relation to me. Yes, sir.
Well, you stood up, so I'm assuming it's in relation to you, but you're not, are you Daniel McDonald?
Yes, sir.
Come on up, Mr. McDonald. That's nothing funny. We don't have time for these games. Come on up.
I just go by Roman, sir.
Well, all you had to do is say I'm Mr. McDonald. You didn't have to say I'm representing him. I'm related to him. All you had to do is say I'm Mr. McDonald and come
I
forward.
apologize for the confusion.
Okay. Has the state filed an information in this case?
No one calls me Daniel.
One moment. Has the state filed an information in this case?
Not this time, right?
All right, Mr. McDonald, we will see you next month for an arraignment, November 12th at 9:30.
Sir, I haven't entered any type of plea.
I know the state hasn't filed an information. It's not time for you to enter a plea. If the state decides to file an information, you can enter a plea at that time.
Can I motion for dismissal right now based on procedural grounds?
There's nothing to dismiss. The state hasn't filed an information. What are you dismissing?
That I put in an affidavit and a demurrer, a motion to dismiss, and it hasn't been responded to. I think the state attorney has 15 days to respond to that motion, and they have not.
A motion to dismiss what?
The cases, the matter.
The state hasn't filed an information. There's nothing to dismiss. There's nothing to respond to. If the state decides to file an information, you can renew your motion to dismiss. If you're going to represent yourself, Mr. McDonald, and if so, I'll ask you a few questions. But right now, the state hasn't filed an information, so we'll come back November 12th at 9:30, okay?
Sir, I got two more questions if you don't mind.
Yes, sir.
Is there a verified claim against me?
A verified claim?
Yes.
I'm assuming you're talking about an information. The state hasn't filed an information. That's under oath and is verified.
Are there any orders? Can I be released to orders of the court?
Were you arrested?
Yes.
You're not in jail?
Correct.
You were released on orders of the court already.
Is there anything additional, orders of the court, or just waiting on the prosecutor to file additional information?
Right. Not an
Before anything
additional
else
information, waiting on the prosecutor to decide whether or not they're going to file formal charges in the form of an information. If they do, you can enter your plea. And if you want to file a motion to dismiss, we'll set it for hearing.
Is there any reason why they hadn't filed any already?
That's none of my concern. They have a statutory period of time to file an information. And if that time comes or goes, we'll address it. But right now, they haven't filed an information. If you hire an attorney, your attorney can reach out to Mr. Patterson. If you want to represent yourself, I'll ask you a few questions next month and you can speak with Mr. Patterson about it. More likely than not, for self-represented litigants, attorneys, prosecutors only speak to them on the record. So we'll come back next month at 9:30, okay?
Sir, my only problem is I live 6 hours away.
Oh, all right. You can always hire an attorney and they can file a notice of appearance and written plea of not guilty for you. If you want to seek the services of the public defender's office, you can fill out an application. The clerk will determine whether or not you're indigent. And if you are, I'll appoint the law office of Henry Mark Sims to represent you. And Mr. Hill knows exactly what he's doing. He can contact my office and file a waiver of presence or ask that you appear by Zoom. But right now, we'll come back November 12th at 9:30.
I would, if there's any way possible, I'd like to handle these matters today.
Handle what matter?
Any matters in regard to that name. And I know you have business to attend to, so I
Yes,
don't
sir.
hold you up, but
No, you're not holding me up. We are attending
it's
to.
not easy to take 2 days off work to be here and then nothing happened. You know?
Well, I just told you what you can do. So we'll see you November 12th at 9:30.
Thank you.
You can sign this notice.
Good afternoon, Your Honor.
Good
We've
afternoon.
got Henry Davis, 24 CF 42 and 24 CF 59.
Okay.
Your Honor, at the conclusion of my last contact with Mr. Davis, of course, we're here on the trial management, but at the conclusion of my last conversation with Mr. Davis, he announced to me and told me that he would like to represent himself. So I think maybe the first thing we should do is take care of that matter and see where we go from there.
All right, Mr. Davis.
I told him I don't want him on my case. It's exactly what I told him. Same thing I told you last time we were in court. I mentioned to him about the felony battery that I caught here in the jail. The charges were filed 90 days after the 40 days. Well, 90 days within the 40 days, he was filed 90 days. They didn't file within the time. He was telling me, they have 5 years until they can file charges. And I never read nothing about that, but that's what he was going on about. He didn't have no depositions. He didn't even read up on the case. He didn't know how many witnesses was in the case, none of that. He doesn't know anything about my case, but he was willing to go to trial on my case before he even knew anything about my case. I don't know how I was supposed to go forward with this man. I even told him to file something. He told me that's a waste of the court time for him to file it, so he's not going to, which I presented to him and said, well, you're supposed to be working for me. You're supposed to look out for my best interests. So
What did you want Mr. Williams to file?
On the felony battery that I caught in here, it was supposed to be 40 days until they filed, as everybody knows, but it was always a 90 days. That charge held me without bond. And it says it's supposed to be released, but I know I can get released because I have other charges, but still, it should have released me in the system so I would be able to bond out, go get my lawyer and get everything right that I needed to. I still was not. I tried to explain that to him. It didn't register or whatever. And he said, we can't, we don't have a communication, we need better communication. Which, as I told him, if I'm explaining something to you, you're trying to tell me, no, that's not what it is. Obviously, there's no communication that needs to be fixed. You're just trying to tell me what the book says is not true. So I would like to remove him off from my case.
Mr. Williams?
I think what he's saying, Your Honor, with regard to the 24 CF 59 case, that's the detention, the battery in the detention facility. He feels that since the state did not file the information in that case within 30 days, that charge has to be dismissed. I explained to him that the statute of limitations on a third-degree felony in Florida was 3 years. So the state had 3 years to file that charge, that it wasn't barred from filing that charge by the statute of limitations. That the procedural rule he was talking about is if you're in jail, if you're put in jail and a charge is not brought in a certain period of time, if the information is not filed, then they can't hold you in jail any longer. But it doesn't mean that they can't eventually charge you in the case. And in his situation, he was already in jail on the 24 CF 42 case, so that it had no practical effect in this matter. So that was what that conversation was about, and it lasted for quite a bit of time. And then eventually, I told him I was not going to file a motion to dismiss based upon that because there was no legal basis to do it. And he had his opinions about the legal issues involved, and I explained to him that was my decision, and that what we really needed to do was to talk about the case, that we had a trial coming up next week, and that he needed to assist me in preparing a defense for him. He just refused to do that. So.
All right, anything else? Mr.
When I
Davis?
first met this man, I tried to speak with him on that first case. He told me And I'm in that verbatim. None of that matters. What I'm saying is, all of that stuff you're saying, we need to just, who you got to blame for? You can't blame nobody else, it's just y'all two. Not knowing I even had other witnesses so-called on the case. That's what he said, verbatim. So I'm not finished. Listen, we both grown. I ain't got time, I ain't got to really lie and play around. I told this man, listen, he's talking about 30 days. It says 40. I never said nothing about no 30 days, none of that. I said 40 days, as I just sat here and told you. I told him, I said, listen, this case that we're talking about is the case in here. If they would have released me on that case in the system, I would have been eligible to bond out. They did not do as the law says do. Or that doesn't matter, you was charged on another case. Well, that other case does not have nothing to do with this case. We're talking about this case, not that case. You're trying to, you keep trying to run these cases in together. You're constantly doing that. You're trying to get me you're not a trial lawyer. You don't want me to go to trial. You want to take a plea. You've been shooting for this plea since I met you. It's the same thing you keep shooting for. You keep shooting for a plea. I told you I'm not pleading. I'm going to trial. I've told you this. You keep constantly, well, it don't look too good for you. Well, you're my lawyer. You ain't supposed to be telling me nothing like that. You're supposed to be like, okay, what can we do? What is the defense? Where can we go? You're not asking me none of that. You're just trying to, okay, just go ahead and sign and get it over with. You're constantly just making up stuff and just trying to go along, trying to make it sound so sweet on your side. I'm not gonna lie to you. I'm not gonna lie on you. I have no reason to do that. You can ask these officers. If I did something, I'm gonna tell you I did it. I have no reason to lie. So as I'm sitting here telling him, I do not want you on my case. You are very incompetent. You're not fit to work my case. I don't feel like you are, because you have not wanted to ask me, hey, let's talk about what happened in the beginning. Hey, let's talk about the beginning. How did this start? How did everything start? You not once asked me that. Not once have we even gotten close to that. Every time it's, oh, no, that's not right. Then he tell me about the case. Well, I watched the video. I'm trying to, oh, you can't tell me nothing. Come on, I watched the video, man. You can't tell me nothing. Come on, just, but now in here, you're just, you're trying to all sweeten it up, and I'm not with that. I do not want this man on my case. I'd rather not have him on my case. He's not fit to work my case. And that's just the end of that.
All right, Mr. Williams is a trial lawyer. He's been a trial lawyer for some time. After listening to you, Mr. Williams, I'm going to find there's no reasonable cause to believe that Mr. Williams is rendering ineffective assistance to counsel. If you want to discharge Mr. Williams, I need to advise you that the court will not appoint another attorney to represent you. So if you still want to discharge Mr. Williams, I'm going to take that as a exercise of your right to represent yourself. And if you want to do that, I'm going to need you to place you under oath and ask you a few questions. Is that what you want to do? Is that what you want to do?
Mm-hmm.
Okay. Raise your right hand for me.
Yep.
Could you tell me your age and your highest level of education?
27 years old, and I got my GED.
And do you have any familiarity with the court system?
Yep.
And what's that familiarity?
Well, I have a book that I look up, but I know my law. I know I'm supposed to be charged with domestic violence too, along the guidelines of domestic violence. We ain't gonna speak on that here today because you said that that's for a jury to decide.
You just need to answer my questions. Mr. Davis, do you understand the advantages of having an attorney represent you?
Somebody this time?
Do you understand the advantages of having an attorney represent you, Mr. Davis?
No.
Do you understand that an attorney is trained in the rules of evidence and courtroom procedure? Do you understand that?
Guess so.
Is that a yes?
Yes, so, sir.
Do you understand that being trained in the rules of evidence and courtroom procedure, attorney can give you advice on how to proceed with your case?
Yeah. Can I ask you a question?
You can answer my
With
question.
that advice, can he tell me that he's not going to file?
Mr. Davis, you can answer my questions.
Okay.
You understand? Do you understand that?
Uh-huh.
You understand that if you want to represent yourself, what I'll do is I'll hold you to the same standard as an attorney. Do you understand that?
Mhm.
Is that a yes?
Yes.
Do you understand that the lawyer can call witnesses for you
Yes.
and can compel the attendance of witnesses?
Yes.
You understand that the attorney will be able to question jurors during voir dire?
Mm-hmm.
You understand that?
Yes.
And
Everybody
you
else shaking their head. You just keep, because you're trying to.
you're shaking your head, but you're not answering me
Everybody
audibly.
else did the same thing. standing right
Listen,
here.
listen to me, that we're recording this, so I need to ensure that you are competent to represent yourself, Mr. Williams. You understand that? You understand that?
Yeah.
The advantages of having an attorney?
Mhm.
Understanding that you still wish to waive your right
Mhm.
to an attorney? You want to represent yourself? Do you understand that if you represent yourself, I'm going to hold you to the same standard as an attorney?
You just asked me.
Do you understand that?
You just asked me the same
Do
question.
you understand that?
Because you just asked me that same question.
If you don't want to answer my question, I'll find that you're not competent to represent yourself. Mr. Williams is still on your case. So just answer.
Because I told you.
Answer
my
my
rights is if I don't want him as my lawyer.
Would you answer my question, Mr. Davis?
All right, I just answered that question. You're gonna keep asking me the same question over and over again.
Do you understand you would not get any special treatment from the court? Do you understand that? Let me ask you again. Do you understand if you represent yourself, you are not getting any special treatment from the court?
I'm not getting special treatment now. Why would I get it then?
I'll ask you one more time. Do you understand if you represent yourself, you are not receiving any special treatment from the court? Is that a yes? You don't want to answer that question, Mr. Davis? Do you understand that you have trial Monday, jury selection?
Didn't know I had trial Monday.
Do you understand that you would not be entitled to any continuance simply because you want to represent yourself? If you don't want to answer that question, do you understand if you are convicted on appeal, you can't raise the issue that you did not have an attorney to represent you? Or that counsel was ineffective since you'll be representing yourself. You understand that?
Why do you feel like he's competent to represent him? When I just sat here and told you everything. Everything outside what I said, you still said he's competent to represent.
Do you understand that if you are disruptive in the courtroom, I can terminate your right to represent yourself and appoint counsel? You understand that?
I appoint him.
Do you understand,
me, I try.
Mr. Davis, that if you disrupt the courtroom, I can terminate your right to self-representation and I can appoint counsel to represent you? Do you understand that? If you don't want to answer my questions, I just find you're not competent to represent yourself, Mr. Davis.
Oh, you don't gotta worry about it.
All right, I'm going to find you're not competent to represent yourself, Mr. Williams. You'll stay on the case.
No, you won't.
So we
I know my
have
right.
a jury selection on
It isn't.
Monday.
Get off my seat.
A few things, Your Honor. if I could.
Mr. Davis just voluntarily left the courtroom.
I know at our last hearing, there were some issues raised about the score sheet, and I just wanted to update you on that.
Yes, sir.
If you recall, Mr. Davis had claimed that there were things that are on the score sheet that he hadn't done. And I told the court that we would look into that and I'd get with the state attorney. We have done that, and we have a corrected score sheet now, which basically changed his lowest permissible sentence from 76.950 months to 56.10 months. So that's a 20-month reduction in the LPS. And I haven't had a chance to talk to Mr. Patterson, but previously the state's offer had been that LPS. I assume it would probably still be the LPS, which would be 56.10 months.
Yes, that's
If you're not prepared to answer that, I didn't mean to catch you off guard, Mr. Patterson. That's fine. Okay. Well, I just need to know that
Yes,
so
sir.
that I can at least try to communicate. Well, I don't know that it really is in play anymore since I guess today's the cutoff date for that, isn't it?
Well, we can bring him back tomorrow if Mr. Davis is interested in accepting the plea,
Okay.
or we can talk to him about it.
Well, I can go see if he'll talk to me.
Oh, we have time this afternoon if you want
Okay, I'll
to
go
see.
see it and then I'll
Okay.
come back. Okay. Your
All
Honor.
right, that's what we'll do.
The other thing I wanted to, I did want to correct just for the record that, he said I didn't have any idea what the case, what was going on. He mentioned depositions. I have reviewed all the discovery in the case. Mr. Hill previously had represented Mr. Davis and conducted depositions. I have obtained all of those, the audio recordings of all of those depositions. I've listened to every one of them. I just wanted that on the
Yes,
record.
sir.
All right, Your Honor, if it's okay with you, is Mr. Davis still back there?
Yeah, we can bring him back, talk to him and see if he want to take the plea. If not, just come back out and let us know and
We'll
we'll,
do that.
all right.
And Your Honor, with Mr. Williams here, I know I filed a number of motions related to the trials previously. This was not one of the cases I filed it in because I was unable to get in touch with Mr. Williams to find out his position on such a motion. I as the court's aware, these cases are all new to me. I've sent subpoenas on this case in an effort to try to be prepared for trial. As the court can see from the file, this is a felony battery based on the harm and the injuries done to the victim. A number of the doctors in this case are unavailable. One is actually out of the country. And as a result of that, I feel that I am not going to be prepared next week to present the case because the doctors who were to testify about the injuries received by the victim are unavailable. And as I said, one is actually out of the country.
All right, Mr. Williams?
Well, I wasn't aware of that, Your Honor, but under those circumstances, and I'm sure the state's made reasonable efforts and diligent efforts, so I wouldn't feel right in opposing that request for a continuance.
All right, we'll move this off the trial docket. We'll bring him back on. He refused to return. All right, so we'll just bring Mr. Davis back on November 13th. That'll give you some time to
That'll
see
give me a chance.
with the corrected score sheet whether or not he wants to entertain the plea.
And what was that date, Your Honor?
November 13th at 10:30.
November 13th. I'm sorry. Oh, okay.
Thank you, Your Honor.
At 1:30, Your Honor?
10:30.
10:30. Thank you. Sorry about that. And that's the only case I have, Your Honor.